Usual for my live today. Hello, everybody. I am on both YouTube and TikTok. It's great to see people here. So that I can see comments as well. Okay, so I've been trying to get back into the habit of going live. It's a pleasure to see everybody. As you can see, I'm in a different place than usual. So hopefully the lighting's okay and you can hear me okay. If you're having any problems hearing me, especially on TikTok, if you're having any problems hearing me, can you guys hear me okay? Shall I plug in my microphone or is this working? Donna, Nick, and X, if anybody doesn't mind telling me how I'm sounding. Can you hear me okay? You can hear me. Okay, wonderful. Thank you very much. Right, it is a pleasure. Let's talk about problems at work. Let's talk about issues with your employer, grievances, disciplinaries, redundancies, discrimination. In particular is something that I've been talking a lot about with a number of different people at the moment. In fact, here is a great question already. Thank you, Webbs. Is it difficult to prove a history of discrimination that ended in a final act of redundancy? That's such a good question, Webbs. So let's talk about how you prove discrimination in general, right? Because I think a lot of people don't really know what you have to prove or what you have to convince a judge of. And one of the misconceptions is that you have to kind of prove things like, in the court of law where it's like beyond a reasonable doubt. But actually in the tribunal, it's something called the balance of probabilities, which basically means that the judge needs to believe that there's over a 50% chance that something is true on balance of probabilities. And so it's a lower bar than in like a criminal world in terms of how to prove something or the threshold that you need to cross to prove something. And so let's go like a history of discrimination. How do you prove that? Because, you don't have CCTV footage, right? Like that's the thing. People are like, well, I don't really have, and you don't necessarily have people who are willing to sit in a witness box and say, I saw them doing that. That's actually quite unusual. But what you do have is your own account of what happened and any notes that you took, any text messages or messages that you sent other people about what was said and how it made you feel. And that's called contemporaneous evidence. And the contemporaneous parts, really, that just means in the moment, in the now. And that basically, it's like so let's say that you've had a bunch of interactions with your company over a period, Webbs, that ended in that final act of redundancy. And you have notes from the meetings. You might have emails about the meetings discussing what was said. You might have emails of conversations where discrimination was actually happening in the emails. All of that would count as evidence. And your own statement about what happened also counts as evidence. And I think that's something that people don't often realize is just your account of this is what happened to me is evidence in the tribunal. And often if you look at the judgments, they're all written up on gov.uk. If you look through them, you can see like full judgment with reasons. If you look for some of those, you can see the judge explaining whether or not they found the evidence to be credible. And they often, if you search for the word credible, you'll often see judges using phrases like, I found the claimant to be credible when they told me that X. And some of the ways that you build that credibility with the judge is, you have like, here were the dates where here's the I have the calendar dates. I know that the meeting happened on this date. I took some notes. Here's my account of it. Here's the email I sent afterwards. Here's my recollection of that. So that all of those things do count. So this is why, for everyone, I bang on so much about building contemporaneous evidence, because you can piece it back together afterwards, and that's good. But if you just keep a little track record of it while you're going, at the first sign of trouble, when things start to kind of smell bad, if you start writing these things down, then that can come in so handy later and it can make or break a case. And that's why the very first feature that we built at Vala was the timeline, which is completely free to use. So if you go to vala.uk and you create a free account, you can use the timeline to just keep track of everything. And we also built that first because for people who are going through traumatic situations, we found that they were often having to repeat themselves about the bad things that happened to them. And so we wanted to build somewhere where they could hold in that information and just share it with someone rather than having to say it over and over. I hope that's helpful. Webb says, for context, it's more to do with timelines, so the harassment discrimination isn't struck out. So Webb's, we did a webinar about how to prepare or how to argue for out-of-time claims. So for discrimination, you might have a redundancy claim, but then you also might have a claim to do with the redundancy, but you might also be claiming discrimination. For discrimination, the continuing act of discrimination is a way that you can, if you had one act of discrimination that was in time, you can then use that to chain to older acts that would have been out of time. And there, what you're looking for is often it's to do with the same protected characteristic or the same kind of activity, to kind of chain those two things together. But we have a whole webinar on that topic. I believe Rebecca's in the chat and she can drop in a link in for the webinar. I think it's about £17, and you just, if you have an account, the link will take you straight through. And if not, you just need to create a free account and you'll see the link. And it's called How to Get Your Out of Time Claim Heard. Okay, loads of questions already coming in. I love this. Right, so hello, this is a YouTube question because I'm live on both at the moment. Hello, in my preliminary hearing, I put forward indirect discrimination, sex discrimination, but the judge has changed it to direct. I'm a litigant in person, so I agreed. Isn't this harder to prove? Sean, that's a great question. Direct is hard to prove. Indirect can be difficult to prove. If the judge thinks that it is typically when I talk to judges, they will, I had one judge point out to me, for example, how a lot of litigants in person didn't know about discrimination arising from a disability, and he was often putting them onto that because it was an easier one to prove. And often he felt like it was the more appropriate one to prove. So the judge probably genuinely did feel like it was a better fit for the situation. Hi, Mallory. A better fit for the situation that you were in. And it's very common for judges to change the claim type at the preliminary hearing, especially for litigants in person. And also they're just exercising their judicial discretion there. You can, if you think that there is a really strong case for indirect, you can ask them to add that as a second claim, but you'd need to bring them something other than what they saw at the preliminary hearing to make that argument. Okay, so let's just keep going. A few other questions. Let's see. The tribunal is the reason that the employer didn't respond to the ET1 in time. Can I still apply strikeout? JM1, I would, you can certainly try. I would bring it up at my preliminary hearing, but given that it's the tribunal that is the reason, I think you'd struggle with that one. I'm a man and I was nicknamed Princess by my manager when I asked for help. Now, Khan, first of all, I'm sorry to hear that because that sounds very much like it could be a potential harassment related claim if you wanted to look at that. Just to talk about harassment, what is harassment when it comes to the Equality Act? Harassment in the Equality Act is essentially bullying because of a protected characteristic. Bullying in of itself is not a legal term, but if you are creating if you are doing something because someone has a protected characteristic in a way that is meant to belittle, dehumanize, degrade, humiliate them, then that plus the protected characteristic, in this case sex, could be considered harassment. So yeah, I think that is worth thinking about in that context. We have an article on our website called The 6 Types of Discrimination, and we have some harassment specific stuff. I would definitely look at that. Okay, let me just see. Next questions. You're very welcome, Sean. What are common things to ask for in settlements except for money and a reference? For example, a car or training? So many great questions today. This is fantastic. So JM, first of all, well done for remembering the reference, because that's something that people often forget. And I think it's one of the best non-monetary parts that you can get from a settlement. Sticking with money for just a second, I would definitely also think about potential future losses or job seeking expenses or things like that. So if, for example, you think it's going to take you another 2 months to find a job of the same kind of quality or pay or benefits or something like that, then that is something that we do see going. It would go into a tribunal award, potentially like a schedule of loss, so it can go into a settlement hearing. Car and training, I haven't seen those as often. Car, if you had the use of a car through the job and you are now suffering because you do not have the use of a car and that is impacting on you, then I could definitely see you saying, like, for example, I need X amount to maintain access to a car until I can get a new job, and it's going to take me 2 more months or however long to get a new job. Then that's the sort of thing that that you could make the argument for. The thing that I like to talk about with losses in general, and it applies to settlements or the schedule of loss, is basically think of it like the Marvel movie timelines, like the Loki one, where, you have the timeline, the main timeline, and then you have the event that happened that caused the branch. That branch was the mistreatment that you suffered, whether it was an unfair dismissal, the discrimination, anything like that. When you're calculating losses, you're essentially saying, well, what would have happened if that breach hadn't happened, if that bad thing hadn't happened? I would have had access to this car at this rate. I would have had this level of benefit, this level of pension, etc. And now I have something worse than that. And so the gap between those two things, that is what your losses essentially are. And so hopefully that will give you some more ideas about how to think about that. Let's see. Would you say I'd be worth it to take an employer to court over an unethical firing? Good question. I would say, so unethical is a very interesting word that you've used there, because unethical isn't something often. There are some ethics codes that are enforced by the law. I can't think of one off the top of my head, but I know they exist. But I often talk about the difference between illegal and immoral. Like, something could be morally wrong, but not illegal. And often that is the case, unfortunately, is that something isn't morally or isn't legally wrong, but it is morally wrong. Taking your employer, but it is often the case that something is both morally and legally wrong, or unethical and legally wrong. What I would suggest to you, Amelia, is look for the legal part and try to separate out what was unethical about it and what was just plain up illegal. And so a lot of what I try to teach people to do on these channels, on YouTube, on TikTok, on our website, in the platform, is to match what happened to you to the potential legal claims that you could make in tribunal, so that you do have that legal leverage. And it would only be if you could match it to a claim that it would be appropriate to take it to tribunal. If it's just unethical but not illegal, or you don't believe that there is a legal claim, then it wouldn't be appropriate to take to tribunal. Does that answer your question? Okay, I've got a few more. Let's do one on YouTube, and then I will jump back to TikTok. There's so many great questions here. Right, so Mallory on YouTube has a question about disclosure. I disclosed a list of over 400 items, and they disclosed a list of 21. This is wildly short. Yes, it is, Mallory. Can you talk about the litigant in person making a cost application? And they followed up to say, I did send them a thank you for your list. It seems incomplete. Do they wish to add to this by the deadline? And they came back immediately to say, and we'll find out because Mallory hasn't finished typing. So just while Mallory's typing, just for everyone else's context, disclosure is such a powerful, important thing that a lot of people don't know about. And it's really important on both sides. And I often refer to it when people have made a data subject access request and the employer doesn't comply with it. And they say, well, what do I do? Because the ICO isn't enforcing it. And all of this is about evidence collection. Like, for example, you might know that there were emails going on. You might know that they were discussing you. and that they made decisions about you, and you want to see those emails because that's evidence. You have 2 bites at the apple for this. The first one is the data subject access request, which has nothing legally to do with the employment tribunal. Completely separate legal process. It's part of the GDPR. And it's really just about you and your own personal data. You could submit a data subject access to, I don't know, ASOS or JD Sports to find out what data they hold about you. It's completely independent. It's just that you can also submit it to your employers, and you can get any information where your private data, where you have been personally identified, which includes things like emails and messages about you. The enforcement for data subject access requests is not robust. The ICO doesn't typically get involved to enforce if an employer doesn't really follow the process. But if you then go to tribunal, your employer will then have to follow the disclosure process later on. And that is where both sides are legally required to share any information that they have about the case, whether or not that information is good for them and for their case. And the process that Mallory is describing is the first step of disclosure, where you don't just send all of the evidence over. You give a list of all of the evidence that you have. And that might be like email between person A and person B discussing person X between these dates, or like contract or document, those sorts of things. And so you kind of go through the list. When the process works, you both send a list, and you kind of pick and mix and say, I want to put this in my evidence bundle, I want this, I want that. If the employer is not playing ball, they might do something like Mallory is describing here, where they clearly have evidence that they are not disclosing. And there are 2 things that Mallory could do here. I'm sure they probably know about both, but I'm just going to list it out for everyone. The first one is that they could ask the tribunal for an application for specific disclosure. And that's where you say, I know they have this. I know they have it because I wrote the email, or they have that document, or whatever it is, but they're not disclosing it. Please, tribunal, will you force them to go and get that document and give it to me? So that's one thing. And then the other thing that they can do is what Mallory suggested, where you can say, well, you're clearly not playing ball here, and that has consequences. If you don't play ball in the tribunal and you really piss the tribunal off, then the tribunal can make you pay the other side's legal costs if you lose. So let's say that Mallory went through their case and they won. If they had warned the other side before that, if they had warned them and said, because you're not playing ball, I'm going to try and get my costs paid for, then they could apply for it, and the court could then evaluate, well, how much were they misbehaving? And if so, force the employer to pay costs, like legal costs. Now, this is often a tactic that's used the other way around, and it's not very widely enforced, but it is the mechanism to use if people aren't playing ball. Mallory, I would look, so you absolutely can send a cost warning letter. And the other thing that I would look into is preparation time. So for litigants in person, because you don't have like a lawyer representing you, there's something called a preparation time order that basically values your time. I can't remember how much it is. Like it's like £40 an hour or something like that. And so if you keep a little timesheet while you're doing your case, if you think that this is going to become relevant, then you can say, well, I would like to, and this only applies if the employer is behaving so badly that they might have costs awarded against them. It doesn't apply in most cases, but you could then say, well, I'm going to apply for this preparation time order. If you want to talk to one of our coaches, they could help you put that together, but that's what I would think about doing. Sorry, that was a long answer. Are people still with me? Is this making sense? Tell me what you think. I hope that makes sense. Cool, right. Oh, loads of questions. Okay, good. Yeah, there's a few people saying, yes, it's making sense. Excellent. Right, let me go through a few more over on TikTok. Lauren, I just received my data subject access request. It's heavily redacted and also omitted conversations I know happened. There you go. I suspect their argument will be that I wasn't mentioned by name. Is there any recourse to push this? Lauren, exactly the same answer. So a data subject access request does only work if it is you mentioned by name, because that is the personally identifiable information. But you will get a second bite at the apple with disclosure. So for example, they might have sent the document but redacted the hell out of it, for example. You then know that that document exists. And so if you go into the tribunal process and they don't disclose that document and they don't need to redact it, they have some justification for redacting at tribunal, but way less than a data subject access request. So if they redacted it to the same degree or didn't even disclose it, you could show the document to the tribunal and say, well, clearly this document exists. Please ask them to give it to me. So that's typically kind of how we see that working out. Right. Let's see. I contributed to dismissal, but HR never proved it. Should I admit wrongdoing at tribunal if minor? I am not going to answer that one. I think you should speak to a coach about that one, because that is above my pay grade for a TikTok or YouTube live. Okay, so Khan is asking, I want to ask, can I go through Acas early conciliation while my grievance is still in process? Yes, this is something that is so important for everyone to understand. When you're going through the early stages of an issue, like a grievance, maybe it's a disciplinary, it will feel like you can't do anything else and everything has to wait until the grievance process or the disciplinary process is resolved. That is not true. If you are coming up to the Acas early conciliation deadline, which is 3 months minus 1 day after the bad thing happened, and the process is still not resolved, you need to start Acas early conciliation and run the two processes in parallel. Because otherwise, you will run out of time. And sometimes even Acas pushes back on this and they said, oh, well, you should have waited until the grievance process was finished. Absolutely not. Do not let them tell you that. Do not believe them. I mean, I understand why they're saying it, but you lose your kind of free, clear path into tribunal if you miss that deadline. It's way harder to get a case heard. It is possible. I just told somebody about the webinar that we have that talks about how to do it, but it is way harder to get your case heard once you pass that deadline. So if you're getting up close to the deadline and the grievance process is not finished, go ahead and start Acas early conciliation and run the two processes in parallel, because you do not want to miss the deadline to be able to start Acas and then file your tribunal claim. That is very important because it maintains your legal power, your ability to take them to tribunal. That is so powerful. That keeps your leverage in place. Okay. So Gareth is asking a follow-up question on this. You're very welcome, Gareth. In early conciliation, how long does it usually wait for the phone call once the form has been submitted? I don't know what the delays are at the moment. I know that people have been experiencing some delays with Acas early conciliation. I wouldn't be surprised if you waited a week or so. If it's longer than that, I would chase. Oh, Mallory has looked. The preparation time is £45 an hour. Someone else is saying, Gareth, that they've heard 4 weeks for Acas to come back to you. 4 weeks is what I'm also seeing on TikTok. Lots of people saying 4 weeks. That's a very consistent number. That's useful to know. The really important thing to know about Acas early conciliation is it pauses the clock. So whilst you're waiting to hear back from Acas, you are still, like, your leverage has been maintained. You're not going to run out of time. It's only when you get a certificate number from Acas, because conciliation, either one or both parties have decided not to do it, or you were unable to reach a resolution. It's only when you get that certificate number that the clock starts again. And normally I would say just stick with a month after you get the certificate number to file your tribunal claim. Sometimes it can be longer, but honestly, I would just stick with a month. So yeah, whilst you're waiting, James waited 5 weeks. Whilst you're waiting, don't worry, the clock is paused. Paula says, I have my appointment this afternoon. I'm so nervous. So first of all, can we all give Paula love hearts? I'm just gonna give you some love hearts, Paula, well done. It's so nervous, like it's so nerve-wracking. And I would just say, Paula, first of all, does anybody have any tips for Paula? You're getting love hearts over on YouTube as well. And what I would say is just give a clear account. They're going to ask you what happened. They're going to ask you, how have you tried to resolve it so far? And so you could say, or I'm still in the grievance process, or the grievance process finished, or the disciplinary, or whatever it was. And then they're also going to ask you, what do you want? And so if you have, so you can say, for example, would be open to negotiating a settlement. They might push you for a figure, but if you don't know what the number is, don't be pushed into it. They can call you back after they talk to the employer and try and get a figure from you. And if you want help figuring out a figure, that is what we built the merits assessment product for. It's on the homepage of vala.uk. It's the product that's £149, and you will talk to a coach and they will help you figure out what is a reasonable amount that you could win in tribunal if you have some valid legal claims. So I would say my general advice for you, Paula, is don't let them rush you. Oh, that's what your call is. It's for your merits assessment. Okay, well, I can tell you how that's going to go because I have complete control over how that goes. So the way that that's going to work is when you purchased the merits assessment product, we asked you to upload some materials and to give us a little message. We then booked in with one of our coaches, who are all lovely. We checked for that. And then what they're going to see is they're going to log in before you do onto the platform, and they're going to see a summary and an overview of your case. And it's actually technology that we've developed to go into the details that you gave us and to pull out anything that we think is particularly legally relevant. So, for example, if there's a discrimination aspect, we might pull out protected characteristics that we think are involved. We will also have built for the coach a updated timeline of the things that we thought were the key points. It's okay if you gave a lot of information. It's technology that's sifting through all of that, and it will have provided a summary to the coach. So they're seeing a summary view, and then they can click in and read the full documents and look for specific details. So that's okay. They're going to see a summary, and we're going to prompt them with that technology to say, okay, these are the most important things that we think so far, based on the information Paula has given, that you should ask Paula about. And that's going to be the jumping off point for the coach to ask you some questions, dig into some details, and then they will form a conclusion and say, oh, I think that is a case, or basically the goal is for them to get to the end and say, I think these are potentially valid claims and these are not, and here is why. And that's what you get as the report as well. Here are the claims we discussed. I think these do have potential to succeed. I think these don't, and here is why. And they will explain a lot of that on the call with you as well. That is our merits assessment product. It's the product on the homepage. Lauren says it put their mind at ease so much, and your coach was wonderful. I'm so glad to hear that, Lauren. Oh, hi, Heather. Nice to see you. So glad to hear that because, I think of all the things, we built this product specifically because of these conversations that I'm having with all of you, because we knew that it's just so hard to understand. Was that legal? Are they allowed to do that? Am I just imagining that this was wrong? Was it immoral but not illegal? That's what we're trying to provide with this product, is that clarity. And Paula, it's absolutely fine that you gave lots of information, because we do a lot of pre-sifting for the coach and summarizing so that they can dive right in with a lot of prep. That's brilliant. So it should be good. Right. Oh, goodness. Aaliyah is saying that they got a cost warning letter from their employer. So the merits assessment was quite helpful. Let me just explain why that's so valuable, and then I'll come back to the YouTube questions. A cost warning letter, you heard me talking earlier about basically if one side takes the piss, normally in employment tribunal, if you win an award, which might be linked to your salary or injury to feelings or things like that, but you don't typically win the cost of bringing the case, so your legal costs. And the other side doesn't, if you lose, the other side doesn't get to reclaim back their legal costs. But there are certain circumstances, basically when one side takes the piss, really egregiously, where the court can decide to make the person who took the piss, whether it was the employee or the employer at tribunal, to make them pay the legal costs of the other side. And they'll means test it as well, but it's a thing. And the only way that they could do that is if during the process, one of them sent the letter and said, hey, you're taking the piss, and I'm going to ask them to pay these costs. I'm going to ask them to make you pay these costs later. It's called a cost warning letter. And this is really designed for an edge case. It's literally less than 1% of cases where a claimant has had to pay costs in any given year in the tribunal. But what employers have learned that is if they send this letter, this warning letter that says, we think that you are taking the piss because we think that your claim has no legal merit and that you're just taking it forward just to be vexatious, for example, that's often the word they use, that, and we're going to come after you afterward. If you lose, we're going to come after you for our costs, and it could be tens of thousands of pounds. They've learned that if they send that letter, then people freak out and they often drop their case because it's scary. And how do you know? Like, how do you know that it has merit or not? You're not a lawyer. And what they don't tell you is that even if your claim has no legal merit, but you believe that it does genuinely, you're not just using the courts to terrorize the employer, then you're still not taking the piss. You're still not doing that. That's why it's less than 1% of cases where it's actually awarded. Like, so that's what they don't tell you. It's a really well-known intimidation tactic. We try to warn a lot of people about it because it's really scary. It's incredibly upsetting. And it is important to be aware of the risk. It's just that the risk is a different size than what people believe it is. Okay, right. Let's dig into some YouTube questions. Do tribunals look at metadata, and will they call it out if the info is produced after the fact to justify decisions? Thomas, I would say they can look at metadata, especially if you call it to their attention. So I wouldn't rely on them to look at metadata, but I would absolutely be putting into your evidence bundle or your argument for your witness statement, please note that this document appears to have been created afterwards. And you could then say, like, this is an example of someone taking the piss at the tribunal. So yeah, they will take metadata into consideration, but you will need to point it out to them. I'm currently working whilst I have my grievance. Can you still use this? Absolutely, Charlie. I would say 40%, if not more, of people who are taking their employer to tribunal even, which is further beyond where you're going, are still employed there. And it's very common for people to get a merits assessment from us whilst they're still employed. Because at this point, you're really just trying to understand what is the situation here? Like your employer doesn't know that you're doing this. Like, we don't give them any information. We don't notify them. It's all completely confidential. So yeah, it's a very common thing for people still in employment to use our merits assessment to just try and get a suss of the situation. Aaliyah said that the employer said that my claim was meritless, and the merit assessment said that it had potential to succeed. Yeah, the employer has zero incentive to tell you that your claim could have merit. Absolutely no incentive. Like, the employer doesn't really get a say as to whether or not your claim has merit. The only person that really gets to decide is the judge. And we can give our opinion, and we will tell you if we think that the claim doesn't have merit as well. Absolutely. But the employer does not get to tell you that. They can send this cost warning letter, which is a scary tactic, but remember that, because they will make you feel like you're silly, that you're out of your depth, that you're making things up, all this stuff. Only a judge can decide. And you have the right to ask a judge to decide in the tribunal. That is your right. You are not doing anything wrong by using that right. So yeah, don't let them intimidate you. It really annoys me. Really grinds my gears. Heather is saying that Masuma did a merits assessment and it was spot on. I'm so glad to hear that, Heather. Let's see. The employer created the redundancy selection matrix after the decision to put my partner forward for it. Yeah, so that would be a good example, Thomas, of showing the metadata to show that this was a retroactive justification for a decision. And that would be a really good example of, in an unfair dismissal case, which redundancy follows the same logic. You can only fairly dismiss someone after 2 years of service if you pass 2 tests, and you have to pass both. If you fail either one, you lose as an employer. It has to be a fair reason, and it also has to follow a fair process. And if you can show that they created the decision framework after they decided to do it, then that is a really good example of how they could fail on the fair process, because they clearly weren't following a fair process if they retroactively came up with the justification. So that's a really good example of how you can use metadata for your argument. I've been introduced to my Acas conciliator, what will be involved. So Charlie, the way Acas early conciliation works is that you file the form, Acas will get in touch with you first, the conciliator. Remember, their goal, their job, their targets is to reach a resolution. Their target is to prevent things from going to tribunal by reaching a resolution. So what they're incentivized and trained to do is to get an understanding of your situation, go over to the employer, call up the employer and ask if they would like to talk to them. The employer can say no, you can say no. Either side can say, I don't want to do this. In which case Acas will just stop and give you the Acas certificate number, restart the clock, and then you'll have about a month to file your tribunal claim. But if both sides do say that they want to try and reach a resolution, then the conciliator, they're not supposed to have an opinion. They're supposed to be independent, and they're supposed to basically pass back and forth messages. Like most things that have to do with people, it really depends on who you get. Sometimes they're really on the side of making sure that there's like a super fair breakdown. Like sometimes they don't. If you have something like the merits assessment already done, then when they ask you, because they're going to ask you, what do you want? And they mean money. Like if you could reach a settlement, how much would it be? If you've got something like our merits assessment behind you to justify the amount, that's going to put you in better stead. Because again, remember, their job is to reach a resolution, not necessarily to get the best possible resolution for you. And I think they're a useful tool, but I would be cognizant of their incentives when you work with that tool to make sure that you're not just relying on them to get the best outcome for you, because that is not their job. Their job is to be impartial and to just reach a outcome. Is it best to go through an Acas conciliator or just straight to tribunal? You have to start Acas early conciliation, even if you opt out of it later. You can't go to tribunal without an Acas certificate number, except in a very, very small number of cases, which probably don't apply. So you have to start it. I don't see any issue if you think that the conciliator is acting in good faith. I don't see any issue in engaging with it. And the thing is as well, the conciliator will still want to be involved even after you file an ET1. Like let's say that you say, I don't want to do it, and you're not going to be penalized if you don't want to do it either in the tribunal. But then later you file your claim, you have a really good preliminary hearing, the judge seems to really understand what you're saying, and the employer is like, oh God, I'm going to have to pay so many legal fees. Okay, let's talk. At that point, the two of you can go back to the conciliator that you originally had and say, okay, now we want to try and reach a resolution. And they will facilitate it. And one of the key things that they offer is that they can legally stamp that settlement. There's only 2 ways to reach a legal settlement with your employer, either via Acas, and it's called a COT3, or with a solicitor, and that's called a without prejudice conversation and a settlement agreement, which a solicitor needs to sign off on. The employer typically pays the solicitor's cost like up to like $500, $700, depends on the region. But they can stamp that. I want an apology from my employer for dismissing me and fabricating allegations. So user 602, I understand that a lot. I really understand that. I don't think that the tribunal process is a great process to go through seeking an apology. First of all, in my experience, people rarely get apologies because employers are very rarely willing to admit that they've done anything wrong and to apologize. I have seen in judicial mediation, which is offered in most cases now, where things like apologies are more common on the list of, this is what I would be willing to do. But I think in general, in my experience, there are people who are doing this for the principle of it, to create the accountability, and there are people, and the money doesn't matter at all. There are people who are doing it because they need the money or they want the money to create the accountability. Those are the two situations where I find the employment tribunal is a very good use. If it's just an apology you're looking for, you can go for that, but the tribunal is really kind of set up for money as the main redress for your grievance, rather than an apology. But I have seen apologies popping up now in judicial mediation, so it is worth looking at. Taking on a giant is saying Acas is hit and miss. You get some good and not go so good. Larger company is just a formality. Just get the certificate and take the advice. Yes, sometimes an employer, even if you're willing to come to the table, an employer will just be like, I don't want to do Acas early conciliation, just tick the box and move on. So it really does depend. If you're unhappy with the conciliator, can you request a change? I mean, I actually don't know. But I would certainly say you should try. Absolutely. If you don't think that they're fairly representing you, and they must have some kind of process where you can raise an issue and ask for someone else. Let's see. Someone did say that they did get an apology. Okay, great. So apologies, like I said, I have seen more of it lately because judicial mediation is being offered more, and it is definitely something you can ask for. I just think that the courts are set up for financial redress or for the accountability that comes by going through the court system, having the judgment published, etc. Taking on a giant is saying that I did ask for a different person, but I wasn't able to get one. Right. So Elsie's saying, I submitted late and I don't know if my claim has been accepted yet. I submitted on the 17th of July. Okay, so the tribunal, that's not surprising to me that it might take a little bit of time for it to get onto the system. I want to be really clear about what accepted means, because if you submitted late and the tribunal accepts the claim, what they don't mean is this is a valid claim that is in time. It just means you have formatted this form correctly and we will now put it into the process. The whole, is it late or not, that gets decided by the judge. And so what will probably happen if you submitted late is that the tribunal will take the form, process it, you'll have a preliminary hearing scheduled, you'll go to that preliminary hearing, and the other side, if they're smart, and they will do this, is they will say, this claim was out of time, we'd like you to strike the whole thing out. And they will apply for a strikeout order. Then it will be up to you to argue to the judge that they shouldn't be struck out for some reason. And you do have some reasons that you can rely on. And there are three main tactics. And it depends on the claim type. You can use some reasons for some claim types. It's a little complicated. And we did a webinar about this. The link, we're going to post the links afterwards. If you log into the Vala platform, which is free, you can go to the webinar section and you will see a webinar called How to Get Your Out-of-Time Claim Heard. That will explain how you can make the argument about an out-of-time claim. It's about £17. Let's just see. Oh, thank you so much, taking on and saying that Vala has been really great throughout the whole process, and shouting out to Anne, one of our coaches. That's great. That is so great. So much love for the coaches today. They are fantastic. I filled in my ET1. It's been a month. Nothing happened. Yeah, there is a delay for processing claims. What I have been told. So for those of you who don't know, I'm now sitting with the judges and Acas and a bunch of other people like Citizens Advice at the Employment Tribunal National User Group with the president of the tribunal, where it's like the behind the scenes of the tribunal, where they're like looking at like, how can we make things go faster? How can we clear the backlog? All that kind of stuff. And one of the things that they told me was how they prioritize incoming messages, because they get so many messages that all the courts, the HMCTS staff are understaffed and overwhelmed. But what they did say was, if you submit a request through the platform and not over email, that is what they look at first. And they prioritize based on the date of like hearings coming up and things like that. So let's say you had a preliminary hearing scheduled for 2 days' time, and you sent in a thing and said, for example, I need to delay or something like that. Your message would be bumped further up the queue because your hearing is soon. And they want to urgently look at that. If your hearing is in a month's time, the same message would be bumped further down the queue, and anything near the time would be bumped up first. So it is worth knowing. And if you put into the message that it is an urgent query, they will take note of that as well. And this is within the platform, within the employment tribunal system, rather than over email. They said that they look at those messages first before they look at the email messages. Okay. Does VALA offer a template with the whole ET1 or only the particulars of claim? Only the particulars of claim, Aaliyah. Although if you book some coaching time with one of our coaches, they would be happy to go through the rest of the ET1 with you. It's just the particulars of claim is like the tough part. And so we've really just focused in on that. Okay, I am going to start wrapping up now because I need to go to another call after this. This has been so. I'm going to see if there's a few more questions. Mallory's talking about they consider going with a no-win, no-fee solicitor. And that is the percentage that I typically see as well. They typically take about 35%. So yeah, and normally your case needs to be valued at like a certain amount, basically enough that 35% will cover their costs and be a good business for them. Typically, I would say cases that could settle or win for more than maybe £15,000 to £20,000 would be like the bottom bar, would be my guess. It will vary. Some can go lower. But yeah, that is a normal amount that you might see from a no-win, no-fee solicitor. If you're considering that, someone else has pointed out, double check your home insurance for legal costs. This is in addition to VALA services. You can look at that. Let's just see. Hi, Danae. Do you have any advice on how to deal with an employer who are playing hardball with negotiations and won't admit the slightest bit of wrongdoing? We just had the mediation process last week. So first of all, can we all give Patrick some love hearts, because this is so brutal. It's just such a tough process. Like, well done, Patrick. Let me give you some love hearts. That was 100. Let me give you some love hearts, because yeah, hardball. Like I find that most employers play hardball, and that it can be super stressful. And I would expect, Patrick, I think this is a mindset thing that I'd like everyone to get into. Through no part of the process, grievance onwards, should you ever expect the employer to admit to any wrongdoing, ever. Like, ever. And you should also expect through the process that they will actively try to make you feel like you're a problem just by bringing up the issues. And that makes it very hard, because all of us, we all operate in good faith, and we don't want to be wrong. We don't want to cause a fuss over nothing. And I think the current culture that we have with workplace disputes really takes advantage of that and makes people feel like they're just making things up. And, so many times someone will tell me about something and say, I'm probably making nothing of it. And then they'll tell me the story and I'll be like, oh my God, this is horrible. Like it's like we've swung so far. So, and employers really take advantage of that. And so one thing I would say, Patrick, is inoculate yourself and never expect them to admit to any wrongdoing. Never. I think it's an unrealistic expectation in most cases. And then the other thing that you really want to do is you want to shore up your understanding of two things. One is you have every right to use the legal system to seek redress. If you are an employee who believes that your employer has violated the law, whether it's unpaid wages, discrimination, whistleblowing, unpaid holiday, whatever it is, if you believe that your employer has done that in good faith, you believe that, you have the right to use the system. You are not doing anything wrong by using that system and by raising this issue. Like, that alone is actually quite a radical thing to believe, because so much pressure is put on you to make you think that that's somehow the wrong thing to do. You have every right to do it. And if we don't use it as citizens, if we don't use these things, then we lose them. So you're doing absolutely nothing wrong by doing that. The other thing is, you can build your confidence and hold your confidence by sticking with the claims. And this is what I always bang on about with people. If you've done the work to figure out, and this is why we had merits assessments designed to do what it does, to figure out how to translate the bad thing that happened to you into the legal claims, and you understand how the tribunal will evaluate that. And often I encourage people to go to the gov.uk tribunal decisions website and to look through similar types of cases to yours, and you can see how the judge evaluated it. Just keep coming back to that, because that is all that matters. What the judge says is all that matters. What the employer says does not matter. They do not get to decide. So just try and remind yourself of that when you're getting totally buffeted by these messages that make it out that you're crazy, that you're making things up, that you're being vexatious, all that kind of stuff. Yeah, and it's so hard, in particular, Patrick. I'm so sorry to hear that, when they were friends and then suddenly they turn on you like this. This is such a difficult process sometimes because of things like that. And the other thing I would say, Patrick, is if you haven't been to one of our tribunal support groups, I would highly recommend it. It's very much like this, with even more people. We get hundreds of people in the chat who are talking to each other and supporting each other. We answer a bunch of questions. We check in on how we're feeling. And we do that once a month. So if you just need a little boost, need a little bit of support, come to these lives and come to our support group. If you go to the events page on our website, you can sign up for the next support group. Okay, right. I am going to go now because I need to go do meeting things. Thank you all. Thank you so much for coming today and for asking these amazing questions, for supporting each other. There is such a lovely community going on in both of these chats where people are giving each other support and love, and just that little bit of extra oomph when you're feeling really deflated. And I think you're all wonderful. I think you're brave. I think you're so brave, because I think that this process is designed to make you feel like you're going out on a limb and that you're just making things up and you're isolated. And all of you are pushing against that, and you're connecting with me, you're connecting with our team, you're connecting with each other, and you're using your rights. And that is so important. So huge well done to all of you. Huge well done. And thank you so much. There's some lovely messages in here. I will see you soon. And I thank you for your time. Have a great day, everybody, and I'll see you next time. We will post before we do our next live stream. I don't know when I'll do it. I'm traveling. I'm on holiday next week, so it'll probably be the week after, but hopefully I will see you then. Bye, everybody. Bye-bye.